Good afternoon. This is the Bills Committee on Interception of Communications and Surveillance Amendment Bill 2015. We have a quorum, and it's the appointed time. Please invite the administration to join us.
政府當局嘅代表嚟講，都係我哋大家都已經喺前6次會議裏。
I'm sure you've met with the admin's team. You've seen them 6 or 7 times before. They are Mimi Lee, Deputy Secretary for Security, Mrs. Millie Principal Assistant Secretary for Security, Ms. Emily Acting Assistant Secretary for Security, Mr. Godfrey Khan, Senior Assistant Solicitor General, Department of Justice, and Ms. Monica Law, Senior Assistant Law Draftsman. On the 22nd of June meeting, there are some issues raised, and the administration has responded to these issues. It's set out in paper CB bracket 21803/14-15 bracket 01. It was given to you all Friday. Perhaps I will give the floor to the Deputy Secretary. Would you like to take us through the paper before we see if members have any questions? Yes. Thank you. This is a response paper to inquiries made in the last meeting. There is a mechanism to enable the Commissioner to directly check the result of the checking, and members ask about the current checking procedure, and we've set this out in the first paragraph. The power of the Commissioner's oversight functions. These powers are set out in Section 53 of the Ordinance. The Commissioner may require any public officer or any other person to provide any information, document, or other matter. The Commissioner may also require the relevant department to prepare report on any case. And the Commissioner is also empowered to determine the procedure to be adopted. Under this provision, the Commissioner will scrutiny in detail reports submitted, including incident reports on irregularities or suspected breach. Apart from that, every week, the Commissioner will also receive such weekly reports from the law enforcement agencies and also the Office of the Panel of Judges. They are all related to authorizations of interception or authorized acts in relation to the time frame authorized. In relation to these weekly reports, the Commissioner may ask questions, and the Commissioner may also take the initiative to conduct inspection visits to these law enforcement agencies to look into certain matters. And at the same time, the Commissioner may at random select cases for checking. The Commissioner will require relevant information, say for example original of applications, a report of discontinuance, and relevant files. Apart from that, the Commissioner may also require specific departments to supply further information and answer questions in relation to these checking procedures. The Commissioner may also look into the device or equipment register and conduct inventory lists checkings and device register checkings, and also check the device stores. Last time, members asked about storage of protected products and when they will be destroyed. On page 2, you will find our answer. In relation to protected products and also relevant documents, we can see them in two separate areas. First of all, whether it is confidential, say for example, the protected products in the form of audio recordings or images. There are clear provisions under Section 59. If the Commission requires that the protected products are to be kept, the law enforcement agency will retain the original protected products for the Commissioner to check, and there is no time limit, and it will be stored until the Commissioner thinks fit to have the products destroyed. And under other normal circumstances, these products will be destroyed as soon as possible. Normally, it will be within 1 month after the operation. If there is no need to retain the information, it will be destroyed. There are also Type 1, Type 2 surveillance, depending on the level of intrusion to privacy. In general, the law enforcement agency will, within 1 month after the operation, destroy the products if it's no longer needed. But if it has to be retained for judicial proceedings, then they will wait for the end of the proceedings and destroy them after 1 year. There may be summaries or extracts produced. You'll find the information on page 2. Whether they are from covert surveillance or interception, when there is no need in the operation, these will also be destroyed within 1 month. And surveillance and interception may involve other documents. In relation to these other documents, maybe they are applications, prescribed authorizations, and also declarations or affirmations. And these are all dealt with under Section 60 of the Ordinance. That is, they will be retained for at least 2 years after the operation. And in case where the products of the surveillance will have to be produced in court, or when there is an application for review by the Commissioner, the products will be destroyed within 1 year after the relevant reviews or court proceedings. Some members in the last meeting asked about details. In relation to the procedure of how a Commissioner conducts checking, and you will find the information thereon. In paragraph 8, the Commissioner, if there is direct contact with the protected products, require departments to submit reports when there is a substantial change or material change in the situation. The Commissioner will verify and check the protected product against the report to see if the law enforcement agency has missed something out. Say if it is an interception of communication, if the report says that the intercepted information lasts for 2 minutes, the Commissioner will check the 2 minutes and check the report to see if it indeed lasted for 2 minutes.
And he will also cross-check to see the efficacy of the protection efforts. And also for the protection of efficacy of the protection, there can be also random sampling to see whether there should have been reports given or non-compliance reports given to the Commissioner, but the LEA had not done so. And this will be one of the usages therein. Another usage is that the Commissioner can do random sampling to see whether the LEA in tracking the target person, whether it is in fact the subject of the prescribed authorization or it is somebody else other than the subject of prescribed authorization. And when listening to the result, let's say it is a prescribed time of however many minutes and it is longer than the however many specified minutes, the Commissioner can also follow up on that as well. So for this kind of checking, it is really talking about one and the same thing, and that is the Commissioner can have the power of coming into contact with the product. And where that is the case, then it will increase and enhance the power of the LEA and also enhance their vigilance that they have to be perfect in the carrying out of their duties, and in turn protecting the privacy of the citizens so that they will not be subject to any unauthorized interceptions or tracking. Now, for pages 4 to 6, Mr. Chair, we are really describing different kinds of information and materials, and it is in response to some of the questions raised by members in the last meeting. If it is necessary, we will be happy to provide further clarifications on these. Well, thank you very much, the administration, for providing a very detailed run-through of the papers and their responses to the questions raised at the last meeting by members. Now we have Mr. Ng Leung Sing, Claudia Mo, in the first round to speak. 5 minutes each, please. Thank you, Mr. Chair. Concerning the report, we can see that every year for the relevant cases concerned, that is the Commissioner, actually for the interception of communication surveillance has a very heavy workload. The Commissioner alone will have to approve all these applications. I would like to know in the future whether there will be an increase to this workload. And looking at the trends of development in society, I would believe that this can only rise in the future. Now, if the Commissioner alone is given this power and duty, performing the oversight functions, and that this function is so important, it is paramount that we should be able to ascertain that there is effectiveness in the disposal or the implementation of these functions. Is there any devolvement? My question is there any devolvement from the Commissioner to other officers so that there is sufficient backup for the Commissioner so that the applications and the cases can be dealt with in fine detail as they merit? Mr. Chair, for the Commissioner, once he comes into contact with the product, he will conduct the checking, and indeed the workload will be larger as a result of that. But it is, of course, not true that for over 1,000 cases, the Commissioner himself alone would go through all of them. For those which are problematic, of course, he will come into contact with them and also listen to them. But as I mentioned, there is sampling And he will do the sampling according to the resources he has on hand. And indeed, it is true, and that there will be resources requirements for this increased function and workload of the commissioner. And therefore, we should consider the resources available to the commissioner as such. There are 20 staff members in the commissioner's office. The highest ranking among the officers is a secretary level officer. And there will be 3 new additional posts in the commissioner's office as senior executive officer, executive officer 1 as the level of the positions. Now, as for whom the commissioner will devolve or authorize which member of his office to take up the work, that will depend on the commissioner, on the cases concerned, and basically the purpose is to make sure that the legislation has sufficient teeth. Yes, concerning the addition of resources in a suitable manner, and where there is limited authorization, I would think those would be factors which would ascertain confidence. I would like to know if resources are to be added, what kind of resources. Will there be judges or other officers? I would like to know how we can make the authorization from the commissioner a foolproof one. That is, that it should have the due confidence that one can feel for the devolvement or authorization of powers. Now, after the bill had been passed, there will be 3 more positions opened, and the commissioner will decide as to what authorization will be given to the new positions. And this authorization will be in written form, and it will be specific in its terms of reference to specify that within the Secretariat, this officer is to be authorized with the power to come into contact with the product. And the principle will follow the legislation or the ordinance. And the spirit is that the fewer the persons coming into contact with the product, the more desirable. And also, the authorized person will have to go to the premise of the LEA before he can come into contact with the information or the product, so as to protect the privacy of the subject concerned. Claudia Mo, I know that legislation has to be watertight in drafting, but at the same time, I think for the ordinary person it will be very difficult to understand the language. For example, paragraphs 4, 5, 6, I have in the report, I have read once and twice and 3 times or more, and I still cannot get it. Can you provide a chart? The left-hand side, you have the scenario or the situation, and the right-hand side, the implementation or the timing. And paragraph 5, you say the cases in the Chinese yi yin. You use that term often, and it doesn't link up, in my mind, the previous sentence with the next sentence. And in the Chinese, you also say that there will be the 1 month, the information will be destroyed within 1 month. But in the next sentence, you do not mention the 1 month. Perhaps it should be added. And then you refer to copies. What copies of what? I mean, it is not clear just from the sentence there as to who is to keep the copies and who the copies belong to, and how can you ascertain that the copies have been destroyed, and what if inadvertently the person tells a family member, a friend, and there had been a recording made of the relevant information. What can you respond to that? Now, also paragraph 9, the last sentence there, can you explain to me? I'm really confused by the drafting. In this case, any requirement that any protected product should be provided to the commissioner would override the requirement to destroy the protected product when it is no longer necessary for the relevant purpose of the prescribed authorization. Can you put this in layman terms? Well, actually, a protected product, we look upon it as the original of a product as a result of intercepted communications and surveillance. As for summaries, excerpts, or copies of the original that you have referred to, and a third area, as I've explained just now, the application for the and also the authorization for coming into contact with the protected document, there is actually this host of documents concerned. So for paragraphs 4, 5, 6, we have talked about the duration. Now, let's say if it is a tape recording, a voice recording that is to be intercepted, the law prescribes that there will have to be destruction of this ASAP. The actual implementation is actually within 1 month after the action has closed. This is not enshrined in the law, but it is actual practical implementation. Now, as where the product is in video or photograph form and can be used in the court as evidence, then the legislation prescribes that because there is a judicial process concerned, then after the conclusion of the judicial process within 1 year, that the same material should be destroyed. In practical terms, if the judicial or the court believes that there is no need for provision of evidence in the court, then within 1 month, this material will be destroyed. Otherwise, 1 year, as described just now, if it is to be put up as evidence in the court. So this should be clear. I mean, that also applies to excerpts and copies. Now, as for related applications or authorization, we have to refer to Section 60. And it is clear here that there is a 2-year retention period, where there is a judicial process. Then 1 year after the conclusion of the judicial process, would there be destruction of the materials? I think this should be pretty clear. I hope my explanation helps with understanding by the members. Ms. Claudia Mo, you have anything to follow up on? The last sentence of paragraph 9, I do not understand it. I'm confused. I read again. Any requirement that any protected... Well, we heard you. We know that. In this case, I read any requirement that any protected product should be provided to the commissioner would override the requirement to destroy the protected product when it is no longer necessary for the relevant purpose of the prescribed authorization. It is so long. Yes, but it is as follows. Where there is an action, it would, of course, interfere with privacy. So there is to be a balance to minimize the infringement of privacy. So the balance is where there is a product, of course, it cannot be leaked, and it should be destroyed as early as practicable. So providing the commissioner with a power to directly come into contact with the product, and in order to avoid the commissioner from meeting with a situation where the product is already destroyed, because it says as destruction as soon as possible. So in the future, the destruction policy should be adjusted so that the commissioner will, according to this new provision, be able to access the protected product. And that is why there is this overriding clause.
I'd like to add that administratively, if this proposal is endorsed by members, in the future, LEAs will have to adjust their policy on destruction to ensure that the commissioner can have access to protected products. That's also my understanding. But the thing is, if it reads like that, all the time limitation for destruction and the justifications will disintegrate. Because, say, I am an LEA, when will I know that the commissioner would like to have access to a certain file? To be safe, I would keep all the files. So that's where I don't understand. A balance has to be struck because it's mentioned in an annual report, and there was also a discussion in the panel that the commissioner would like to have access to the information of a certain case, but it's already been destroyed. That's why there is the proposal that the commissioner will can request to have access to certain information, and that would override the requirement to destroy the protected product. I understand, and in that case, on the safe side, the LEA will keep everything. But if there is no such request, then the LEA will have to destroy the protected product. That means the commissioner will have to say, I don't want 1, 2, 3, 4, I want 6, 5, 7, but I don't want 8, 9, 10. Is that right? And so the department will have to be informed. This is to expand the powers of the commissioner. And there is something that is strongly requested from the LegCo. And they have taken on board our view, and they have struck a balance. I am still trying to understand where the balance lies. So in the end, there is no time frame for destruction. Yes. The department will have to set down a destruction policy in accordance with the law, and as to when the products and the relevant documents will have to be destroyed, they have to enable at the same time the commissioner to perform its duty, and that is the case now. And in the future, if the commissioner would like to have access to protected products, the LEA will have to make sure that it happens, because the commissioner will submit weekly reports. So the commissioner is in a position to know what covert operations have been conducted, and all the details will be known, the offenses and the procedures. And if the commissioner says to the LEA that I would like to have access to the information of this case, then it will have to be retained. The commissioner may not look at every single case, because we're talking about over 1,300 covert operations in a year. Some may last as long as several days. So it's impossible to look into each case. So there has to be selections. And the criteria is that when an incident has occurred, and there are others that are randomly selected, and the LEA would assign a destruction policy. Well, there are some technical proposals. The first one is a decision of the time between the operation and also the time of destruction. Ms. Ng? Thank you. This is also a proposal made by an ex-commissioner. When the panel judge or authorized officers, under certain circumstances, revoke the specified authorization, and from that particular time to the time when the LEA stops the operation, there is an inevitable technical time gap. And if we look at the ordinance in a very strict way, then it's a breach. But that is inevitable, because when the panel judge said that the operation has to cease until the time when it actually ceases, there may be a gap of several minutes or 10 minutes or so. The ex-commissioner asked us to make amendments. The LEA will have to set down a provision that as far as practicable and as soon as possible cease the surveillance or the interception, and the product obtained during this time, this will be seen as obtained under the specific authorization. And there is a question about how as soon as possible is defined. The ex-commissioner is of the view that the time frame can be written into the code of practice, and it's for the commissioner to decide whether the LEA has indeed ceased the operation as soon as possible. And we have made amendments. We've got the consent of the incumbent commissioner. And in the 2013 annual report, the incumbent commissioner said that they agreed to the government's proposal. Any questions? If not, let's move on to partial additional reasons for specified authorization and also revocation of a warrant. And this is also a proposal by an ex-commissioner. The specific authorizations in the ordinance cannot be partially seized. Say, for example, there is an authorization targeting a subject, and there are two telecommunications devices. You can't just stop one and leave the other running. The ex-commissioner was of the view that there should be legislative amendment to enable the LEA to partially cease the operation. And a panel judge also has the power to partially revoke a specified authorization. Another thing is in relation to inaccuracy or of information, or there is a material change of the situation to revoke or withdraw the specified authorization. This is also a proposal of an ex-commissioner. Under the current situation, there are conditions imposed by a panel judge. A common condition is that in an operation, if the LEA encountered material inaccuracy or material change in the situation, the latter is quite common, because if it involves legal professional privilege or an enhanced risk of obtaining journalistic material, then a report will have to be made straight away to the panel judge. We would like to write this into the law. Well, currently, it's only a condition imposed by the panel judge, but we are going to write this into the law to stipulate that where there are occurrence of these situations, a report will have to be submitted to the panel judge for the panel judge or the person making the authorization to decide whether the operation should continue. And in Part C, that is revocation of warrants and withdrawal of retrieval of devices. Warrants can be issued for retrieval of devices, but there is no provision to enable a panel judge to revoke such a warrant. So we would like to amend the law to enable a panel judge to, under certain circumstances, say when a report is made, to revoke a device retrieval warrant. Anything you would like to know more about? About the revocation, can it be partial? You're talking about a part. So whether it's, say, 2 lines or 2 telephone lines, 10 telephone lines. So you're talking about the same thing, device? Perhaps, DS, you can give us some examples. Well, there are 2 areas, a device and interception. That is, say, for example, surveillance. There may be different modus operandi. Say, for example, the subject may have 3 telephone numbers or 3 telephone sets. And in an interception, maybe the application is to cover all 3 telephone numbers. As time went on, they may realize that the first 2 numbers are actually used by someone else, and of course there should be discontinuance and a report to be made to the panel judge. If the panel judge is of the view that it doesn't meet the conditions under Section 3, then the first 2 telephone lines will have to be revoked. So the authorization will be revoked while keeping the 3rd telephone number. At the same time, the panel judge may impose conditions. When it comes to devices, devices are used in surveillance. Say, in an operation, there are 3 premises at 3 different locations. And later, it's found that one of the premises, in relation to one of the premises, the persons involved are arrested. But surveillance will continue in the other 2 locations. Of course, for the first one, the authorization has to be revoked, the operation discontinued, and the devices will have to be retrieved. And for locations 2 and 3, the operation will continue. So when the operation ceases, the LEA will have to retrieve the device. Are you clear about that, Ms. Mo? If that is the case, we will move on to page 4. That is to clarify about the terms relevant person and duration. This is clarification in relation to examination by the Commissioner. Provisions relating to an application, the terms relevant person and duration. We have taken on board the suggestion of the ex-commissioner, who was of the view that they were not clear. The current provisions stipulates that the commissioner may inform the relevant person the duration of interception. And the ex-commissioner thought that that is not enough. Merely informing the relevant person, that is, say, 2 days, was not sufficient. and information, say for example, which year, which month, and 2 days of which time frame should be specified. The ex-commissioner was also of the view that the definition of relevant person was not clear. That's why we propose in this bill to clarify the term relevant person in operations that is not covered by an authorization yet.
All right. Concerning relevant person and duration, the clarification of the meaning of these two terms. Anybody else? Questions, please? No? Yes. Reporting of non-compliance to the Commissioner. Yes, the Secretary, please. For this, again, this is a suggestion from the former Commissioner. According to 54, stipulation 54, the LEA, if there are any officers of the LEA which is expected of non-compliance to this law, they will have to make a report to the Commissioner. And the former Commissioner is of the view that there are situations such as technical errors which arose from previous cases, such as blackouts, electricity blackouts, which was not because of an error on the part of the LEA, but the report will have to specify and lay out very clearly whether it is an error on the part of the LEA. As long as there is any non-compliance, then there will have to be a report raised to the Commissioner's attention so that the Commissioner will have a full picture as to what led to the error or the non-compliance. Members, any questions on reporting of non-compliance to the Commissioner? Mr. Yu? My understanding, Mr. Chair, concerning the reporting to the Commissioner would relate to situations where the police, for instance, will raise a report of non-compliance, and it is voluntary on the part of the LEA or let's say if it is the police department. Now, I would like to know whether there is any mechanism where let's say a law enforcement department, let's say the police is of the opinion that there is no non-compliance, where there is one. How do we forestall that situation? Well, if we look at the Commissioner's report, the LEA, first of all, do report according to prescription non-compliance. And also the LEA had always had the practice of reporting on special situations where the Commissioner need to be notified. They would report on such special situations. Do not have to worry that the Commissioner will have no other means of finding out non-compliance. For the weekly report and also in the investigations or the annual report, there were instances of explanation of such incidents. And also for the products, the mechanism for the interception of communications and surveillance products, as we have discussed earlier in this meeting, there will be a mechanism for the Commissioner to compare whether the procedures and the means are in keeping with the procedures that is enshrined in the law. Now, let's say there were 100 such cases of non-compliance, and the Commissioner had looked into all of them, except for, let's say, 2 cases. Have there been such instances? Well, over the past many years, the Commissioner had found non-compliance cases in his work, and he's found non-compliance of the code of practice as well as the provisions in the legislation. And the Commissioner might have found that certain reports were incomplete in the information contained, and the Commissioner had sent out advice for making good of such reports. In the 9 years of operation, we have had over 10,000 applications. 29 cases have been labeled as non-compliant. And there have been over 20 such cases, and for each of them, the LEA had to follow up. And for some of these cases, it had led to rewriting of internal manual and guidelines, and there have been 26 officers or personnel who have been penalized for non-compliance. James To. Mr. Chairman, first question, paragraph 5. Are we referring to the new document? Which one? Mr. Chairman, are we talking about ICSA 2015-06? Well, you're going back in that case, Mr. To. We have already discussed the annex which you are referring to, but that is all fine. We are now in the discussion part concerning the technical implementation. That is time difference and non-compliance report. We are already at this point of our discussion, proposed order and areas for study. Now, after that, we will go into clause by clause, but nevertheless, Mr. James To. Mr. Chairman, sorry, I have a concurrent meeting. Sorry about that. No, but because this is a response to questions raised by the meeting, and 70% to 80% of the questions were raised by me, and other colleagues may not be so much in the know. Now, I'm looking at the destruction within 1 month for the original of surveillance. Are you talking about voice recordings? Is this about voice recordings, not photographs? So this is the original tape recording. Of course, there is no tape now. There is no voice tape now these days. But this is a voice recording that you're referring to, is it not? Last time I heard from the administration that there are different practices for different departments or LEAs. Is that true? Well, according to Ms. Lee, yes, Mr. Chair, according to the law, the head of the department will formulate the policy for destruction of the product. And the destruction, of course, will have to comply with the law. And that is where the product is no longer necessary, then there will be an early destruction of the product, especially for voice recordings. Yes, it would be as soon as practicable and within 1 month, according to our understanding, where after listening to the voice recording, where there is no further need for further action, within 1 month, the voice recording will be destroyed. So this is a general sense for your information. Mr. Chair, I believe you remember, perhaps you remember, the response was that different departments have different policies. Mr. Chair, that is not in conflict with what I said just now. The general sense is as I have described, but for every department, perhaps there is more precision to the policy. Mr. Chair, however, in the last meeting, I have asked about exactly this. You said that different departments may have different policies. Now, what if one department specifies 18 months and another half a month? I do not understand why you have to answer my question this way, because this is the question I asked you specifically at the last meeting. Ms. Lee, anything to supplement? I have nothing to supplement. Mr. Chairman, I do not understand. What does it mean, no supplement? My question is, for the 4 departments, what is the time period for destruction? Is that a secret? Ms. Lee, 4 different departments, do they have different time frames for destruction? Mr. Chair, for the 4 departments, for the destruction policy, how long they keep them for, how do they protect them? Well, at this public meeting, I can only describe what is enshrined in the law, and secondly, what is the general duration of keeping of that material as a general sense. And also, I've written it out in paragraphs 5, 6, 7 of this report. Mr. Chair, please do not repeat what is already in the report. My question is, why cannot the 4 departments tell us about their implementation? Because this guideline is about the monitoring of the commissioner. I mean, we need the specifics. I do not know about other colleagues. If one department says it specifies 3 weeks and another 2 months, do we accept that kind of secrecy? And without that kind of secrecy, there cannot be any effective surveillance. I mean, why is this a secret? I mean, we do not know who's being surveyed and why. I do not know why this policy can be a secret. Why does it have to be a secret? Well, Mr. James Toh, the Secretary had mentioned that the 4 different departments may have different durations. And it says here that generally within 1 month there will be destruction of such voice recordings. So I understand whether the question is whether further information will be provided where the 4 departments may have different time frames for destruction or further specifications concerning the time frame for destruction. Do you have further information? Mr. Chair, the 4 departments, as mentioned in paragraph 5 in the report, it is as described as such. As for internal codes of practice, that is confidential to the departments. But basically, the general guideline is that within 1 month, where the material is no longer necessary, then it will be destroyed. And the commissioner also, there will have to be a protection where the commissioner may need to come into contact with the products. And would this destruction time frame disallow that kind of work by the commissioner in referring to the product? No, it would not affect that, because as I have mentioned, answered the question earlier, the commissioner if he feels that it is necessary to access the product, then the product, while the product is still there, then the commissioner will be able to do so. Mr. Chair, but it says, well, perhaps I can step back one. If you do not tell us which department it is, A, B, C, and D, can you tell us at least what is the longest duration and what is the shortest duration among these? Is even that a secret? Ms. Lee? Well, Mr. Chair, the 4 departments are specified in the... Well, I do not even know which the 4 departments are. The police department, ICAC, well, I know. But what about the duration? The least is, the shortest is, let's say, 3 weeks. The longest is 1.5 months. Please tell us, provide that information. Which department will keep the information for how long?
Why so secretive about this? That's outrageous. Let me ask the DS. So can you provide the information out of the 4 LEAs, which is the longest, which is the shortest? Just tell me the figures. Let me say that the design of the internal guidelines is something we, the Security Bureau, will not get involved. Mr. To can rest assured that when it comes to LEAs exercising their power, when it comes to interception and surveillance, it's overseen by the Commissioner. So the Commissioner is aware of that. However, for the administration or the electrical, whether they know about the information or not is irrelevant. The most important thing is that there is seamless there is a efficient performance of the Commissioner's duty, supported by the LEA. Ms. Claudia Mo, paragraph 5. I've asked a question. You talk about the originals. Normally, it will be destroyed within 1 month, and then there are summaries and extracts of the originals. I asked about copies. How would you know that all parties involved will not make their own copy? How can you verify that the copies have all been destroyed? And if there is any breach, what about penalties? Because you did not answer me before. Yes. Thank you. Thank you for the question. In fact, according to past reports of the commissioners, when it comes to access to products, there is an audit trail in the LEAs. And if Ms. Mo is concerned that some officers may make copies of, say, a certain dialogue without someone knowing, that will not happen, because access to products will leave trail. And as I said in the last meeting, not only is it impossible to make a copy, how many times this communication has been listened to, whether there is any rewinding, will all be recorded and subject to the oversight of the Commissioner. Ms. Mo. We believe in the system. If you say that there is a fail-proof mechanism, then I will believe you, because trust is very important. Mr. To asked a question, and the administration emphasized that the Commissioner knows about everything, and there is a seamless communication between the Commissioner and the LEA. That means you have to trust the Commissioner as a person. However, Mr. To's question, Mr. Charles Mock's head is in the way. I can't see the chairman. Well, you said there were questions about how do you make sure that the system will be fail-safe and there won't be any cover-up. And you also talked about the Commissioner being in a position to know about everything. And you did not provide any information to us about the system. So we remain unconvinced. I don't have anything to add. But when it comes to the design of the mechanism, the Commissioner is an oversight of the entire system. And the Commissioner will be someone who has been a judge in the High Court. We have to believe their impartiality and independence. We have to rely on an immaculate system and also the authority and credibility of an ex-High Court judge. Mr. Ng Lan Sing. I agree with something Ms. Mo said. Trust. The implementation of a mechanism or system depends on trust. There may be civil or criminal proceedings. When it comes to interception and surveillance, as we see from films, that only the LEAs will have access to the information, and there will be proper records. Well, for short duration is several days, several months, and long ones are just a year or so. Is the duration. If we believe that they can reasonably retain the information, and will not let the subject knows about the period when they are retained, so that they can find ways to circumvent it, to avoid prosecution. From the record, we see that there is no need to change anything, and there is no reason for us to not trust the commissioner. We don't need to force the administration to give us the figures of each department, because it will be meaningless. If the information is divulged, and if the, to put it bluntly, undesirable elements know about this, there will be social cost to pay.
支持政府到呢個為止所提供嘅資料。
And I support the administration for provision of such information. Just now, you talk about the system, and we have to. And the proposal is to increase the power of the commissioner to perform its function of oversight. And of course, we have to have in-depth discussion of some other suitable topics. We're here to talk about enhancing the power of the commissioner. Mr. Yu Si-wing. Well, these products involved privacy, and they have to be destroyed within a specific period of time. If they are retained forever, and it will be unfair to the subjects. So there should be a time frame. And it should be clearly specified, say for example a month, and I find that acceptable. For some major cases, maybe the period of retention has to be longer. We have to trust the system. And there will be a third party, which is someone who enjoys a high level of credibility and authority. We have to talk about reasonable period of time. If it's retained for a year, does it mean that it will naturally be unreasonable? We are here to talk about improvements, so it is meaningless to force the administration to give information about how long products are retained in each department. It will only be used by certain people. Does the commissioner have any views about the period of retention? Does he or she think that for certain products it has to be retained for longer? Do you have any plans or any ideas to change anything? Given the operation of the last year, the Commissioner in general was happy with the destruction policy of departments. When the Commissioner says that there is a specific case that the LEA would require to retain the information, then it will be done, no matter how many years. It's for the checking of the Commissioner. There may be cases involving legal privileges, journalistic materials, and non-compliance, irregularity. And that overrides the period of retention requirement. Just now we talk about 1 month is in case when the product has been used and it served its purpose and is no longer necessary, then within 1 month it will be destroyed. And when the Commissioner has direct access to the product, then the department will have to review its policy. Will the 1 month period enable the Commissioner to make use of the product for checking? If not, then the LEA will have to make adjustments, either by extending it a little bit, and as to the extent, they will have to talk to the Commissioner. And that will be the general practice. In this bill, there is a proposal whereby the LEA have to make adjustments to the new power of the Commissioner, that is direct access to protected product. An adjustment will have to be made, otherwise the Commissioner may not be able to have direct access to protected products because it would have been destroyed. So I think there is a tacit understanding between the Commissioner and the LEA. Over the years, do you think that for certain types of cases or certain types of information, the Commissioner usually will ask for retention of the products? Yes. PAS. Whether it is the incumbent Commissioner or ex-Commissioner, they have not made any request for general retention of products. For cases that are mentioned in the report, they involved legal privileges or journalistic materials, non-compliance, and that they would get the special attention of the Commissioner. The Commissioner said that specific authorizations will have to be obtained before communications can be intercepted. Some products have been retained so that the Commissioner, when the Commissioner has the expanded power to check the products. Mr. James Toll. The Commissioner has mentioned a number of cases that are suspicious, say Wu Kok-heng, because he's is a Commissioner that has held the office for longest, and in a lot of reports, at least 10 cases, this is mentioned. Is it the case that for the 10 cases, the product has been kept to wait for the bill to pass? I don't know whether you will say that, well, I don't know how long we will have to wait for the bill to be passed, so they are all destroyed. So is it the case that for cases identified by Mr. Wu, say LPP or journalistic materials, even when the bill has not been passed, all the products have been retained? PAS.
Mr. Chair, according to our understanding, referring to the Commissioner's report, basically the former Commissioner or the incumbent Commissioner, even though they have not used the power to listen to the recordings, but according to the powers, they have already asked the LEAs to keep the relevant recordings and records, and they have been doing so, that is, keeping the records, waiting for the bill to be passed, and the Commissioner will be able to refer to these recordings that have been mentioned in the cases or related to the cases mentioned by the former Commissioner. Well, Mr. Chair, I want a written confirmation concerning what you said just now. Otherwise, I fear that there may be qualifications in the future or you had a misunderstanding of the situation. I want a written response to that. Now, my question. Apart from the dozen or so cases mentioned by the former Commissioner, as for other cases, there are many other cases. Perhaps they have all been, the recordings have all been destroyed. Is that the truth? Deputy Secretary. Mr. Chair, as mentioned just now, where the judicial process is still in process, where the judicial procedure is still in process for the surveillance concern, for the surveillance cases, they are still being kept. Well, Mr. Chair, I'm talking about voice recordings. Voice recordings mentioned in the Commissioner's report, the dozen or so cases. Have the recordings been destroyed? Because, Mr. Chair, mind you, before this bill is passed, the Commissioner feels that he still has the power, but he's waiting for the passage of this bill. But on the other hand, you're asking, querying whether the Commissioner has a query. And we don't know when this bill will be passed. July is improbable. Perhaps September, perhaps October, we'll see the passage of this bill. Now, going back to paragraph 5 there, does it mean that it will be destroyed, that the originals will be, and the extracts and summaries of the originals will be destroyed within 1 month? I mean, this is the interim. What happens in the interim? What is the destruction period for destruction? Ms. Lee. Mr. Chairman, where there is no LP and journalistic material or confidentiality, no judicial procedures for cases not related to the above said, if the LEAs feel that there is no need to keep the recordings and within 1 month there will be destruction of such materials. That is the import of paragraph 5. As for the dozen cases Mr. To mentioned, actually, if I may supplement, in the past 9 months there had been 11,000 cases all told, and for LLP, journalistic material and other cases chosen by the Commissioner, they are about 200 or so. And from the report, we see that the materials are being kept so that the Commissioner will be able to refer to them, to these recordings when he wants to take up with these cases. Well, the Commissioner, the Secretary had not answered my question. These 200 cases concerning LPP or JM otherwise, these 200 cases, why is it related to the 1 month or 3 weeks? My question is, for the new Commissioner, how much room does he have to random sample to investigate these cases? But if you say that those, who's going to do the sampling now? It is a Commissioner, isn't it? If you say that there are no problems, no case with these for sampling, then and you destroy the recordings, then you are usurping the power of the Commissioner. Mr. Chairman, let me raise an example. Let's say the Commissioner says, I want to look at the February cases. and you say, oh, the LEA says, well, we have already destroyed the recordings. What then? You have to tell the public how long you'll be keeping the recordings for the commissioner to refer back to the cases. Let's say if it's half a year, then the commissioner will know that any cases that had exceeded the half-year period will not be able to be referred back to. So he will have a time frame in mind. Mr. To, that is not the issue. The issue is the destruction of the materials. When? Within what time frame? Well, Mr. Chairman, I understand, but we were talking about, or someone referred to a tacit understanding. Is a tacit understanding what, 3 weeks, or is it half a year? What is a tacit understanding? It is not set out in the law. What is this LEA and commissioner understanding? You cannot have that understanding in secret. Well, how long will the surveillance products be kept? Well, the commissioner will have the power, it does have the power now, and it will have the power for the commissioner to examine the products and go into the cases. But how can there be any... Mr. Chairman, we're talking about surveillance materials, recordings, voice recordings. We're not talking about examination. Mr. To, I heard that the secretary saying that where the commissioner wants to examine the cases, he can do so. Well, actually, the commissioner will have access to the information in the reports, and the commissioner will single out the cases which are non-compliant, and he will and these cases will be kept. The recordings concerning these cases will be kept. But of course, the commissioner will have power to access the recordings in the future. He may not access all the recordings, and it is impossible for him with his resources to listen to all the recordings, and these recordings will be destroyed as early as practicable. Now, this is important as a principle, so as to protect the privacy of the subject or the citizens concerned. And the materials cannot be kept forever, simply in waiting for the commissioner to conduct examination if he wants to conduct examination. So how can the commissioner carry out his power? Well, that is after that we will have to leave that after the passage of the bill for the commissioner to reach an understanding with the LEAs. All right. Ms. Lee, for the commissioner and the former commissioners, for those cases which have been asked to be kept, are they being kept? Yes, they are being kept. Mr. Chair, there are 3 types of cases. 1, those which are kept because the commissioner had said that he wanted to examine those. 2nd, those which the commissioner feels that there are certain cases which may be problematic or non-compliant. And thirdly, there are types which may be random sampled for the commissioner to look into. Not that the commissioner had said that they are problematic. As for those which the LEAs feel are problematic, well, we can understand that the LEAs would not very often voluntarily say that they are problematic, their own cases. I'm not saying that the LEAs leave the information or recordings intact for time on end, certainly not forever, not for the next 3-5 commissioners. But the question is, for how long? So that the commissioner can access information which comes under Class 3 or Type 3, as I have described just now. Ms. Lee. Yes, for those cases which have been mentioned by the commissioner for further examination, those cases have been kept. I think Mr. To's concern point is as follows. Yes, whether the cases or materials concerning the cases have been left for sufficient period of time so that the Commissioner can conduct random checks so that he can, which is part of the power of the Commissioner. Now, this issue had not been resolved as of now, and I can also understand that it is impossible for all the cases to have been kept until the Commissioner says that they can be destroyed. It is impossible and for that to happen. So the administration is saying that the Commissioner will have to reach a certain consensus, a practical consensus with the LEAs concerned. And it is up to the members to say whether this is acceptable or not. Exactly, that's exactly it. And the term used is not consensus, but tacit understanding. That's the term she used. And my question is whether this is up to the decision between the Commissioner and the LEA, or whether this should be set out in the law. Ms. Lee. Mr. Chair. In the present round of drafting, we have taken into account a suggestion made by the members, and that is the LEA, for their future arrangement for destruction, they will have to take into account this new power of the Commissioner. But as for how long the materials will be kept, and we have not thought of putting this into the present draft of the bill. According to paragraphs 4, 5, 6 of the report, in different stipulations, it is specified under what circumstances the materials will have to be kept for 1 year, or when, under what circumstance, the materials will have to be destroyed within 2 years. Now, that has been specified. Now, Mr. Chair, I want the government, the administration, to go back to consider whether this can be set out in the law. Secondly, at least you have to get the approval of the present Commissioner of setting it out in the report. But I fear the scenario where you do not set it out in the law, but set it out in the report, it is still confidential. And it is maintained, let's say, that we do not want those who want to perpetrate any ill doings to know of the period of maintaining or keeping the materials. And we are going into a level of monitoring of the Commissioner. I mean, I'm going already backwards many steps, and I know that I'll be criticized for so doing, but I will leave you this opportunity, give you this opportunity for you to go back and consider this. Mr. Chair, I will bring this back to the Commissioner because all the recommendations we take to the LegCo have actually been consulted fully with the Commissioner beforehand. Well, Ms. Lee, Mr. Chair, I hope that Ms. Lee will come back to this panel. If you say that the Commissioner is silent, then I will go to the CSA stage. Mr. Chair, Mr. Yu, Mr. Chair, it is very clearly set out the powers of the Commissioner, what kind of information the administration will have to provide. All that is laid out very clearly. And it is now a question of where we draw the line, that there should be a line drawn after consensus is reached between the LEA and the Commissioner. And the law cannot be very clear on that line. But as a guideline, the law had given the Commissioner that power or right. As to the line to be drawn, perhaps the guideline can throw certain light on it. That is for these products or the materials that the Commissioner would want to examine. If the Commissioner feels that they should be maintained or kept for how long, then there should be a line drawn, a time period that is reached as an understanding between the Commissioner and the LEA? Well, perhaps, Mr. Chair, we can, in the Code of Practice, perhaps respond to Mr. Yu's point there, and that is provide some guidance as to that line to be drawn between the Commissioner and the LEA.
Ms. Mo, I'm confused. I thought random checks. The two words refer to checking at random. But the more I heard, it sounds like cases that are significant will be selected for checking. Why? That's my first question. DS. There is no confusion. No matter what checkings are done, the aim of the Commissioner is to find out if the LEA has done anything untoward. So whether it is in relation to LPP, journalistic material irregularities, and incident reports, they may be selected, and there may be on top of that random checks. An ex-commissioner said that what if there are cases that are reportable but not reported? It doesn't mean that the Commissioner doesn't have the power now. It's just that since there is no stipulation, the Commissioner does not have direct access to protected products. As a result, the Commissioner focused on incident report. When it comes to random checks, the Commissioner would like to do so after they have obtained the power to have direct access to protected products. Mr. James Toto mentioned a term you used, tacit understanding. Tacit understanding between the Commissioner and the LEA. If that is the case, then it won't be random. Back to my original question. There are 10 cases. The Commissioner said 1, 2, 3 you can destroy and keep 4, 5, 6. But 7, 8, 9 I will consider them for a while. Back to Mr. To's question. What is for a while? How long will these products be kept? Can you clarify them? Can you clarify this more? What is there to clarify? What's your question? Well, you said that there will be random checks, surprise checks for big cases. The PAS mentioned there is a tacit understanding. If there is tacit understanding, then it won't be random. Under the provision, the Commissioner may set down the determine the procedure to be adopted in performing any of the functions. When I said tacit understanding, I was referring to destruction of products. If the Commissioner said that, well, you keep everything for 1 week, but if by keeping them for just 1 week the Commissioner cannot perform his or her function, that it will be meaningless. So there should be tacit understanding between the Commissioner and the department, so that departments will adjust their policies to enable the Commissioner to perform its function. Yes, there needs to be clear communication to enable the Commissioner to perform its function. Would you insist on using the word tacit understanding? Because it makes me feel uneasy. Well, if that is the case, I won't insist on using this term. What I was trying to say is that in relation to product destruction, the LEAs will have to tie their efforts in with the Commissioner. Mr. James To. To facilitate your provision of information next time, currently, Clause 13 says that the Commissioner may require any person to provide information. Can the Commissioner require certain products to not be destroyed before he or she requires some information to be provided? This is a general question. Does the Commissioner have this power? Or is it the case? Well, I asked you to provide information of a certain case. But if I ask you to not destroy products over a certain period, the Commissioner doesn't have the power. So the Commissioner will have to have a tacit understanding with the LEA for the LEA to put in place accommodating arrangements. From the weekly report, the Commissioner will be on top of the situation, and if the Commissioner thinks there is a need to check the case, the LEA will have to keep the product. Well, just let me give you an example. I hope you understand. Say the Commissioner realize that certain information has to be kept, and the Commissioner may ask you to do so. And say, for example, if the Commissioner is of the suspect that there may be irregularity, can the Commissioner ask a particular LEA to keep products of all the cases over a specified period of time? Well, there is unfettered power set out in Section 53. Perhaps you'll listen to the rest of the answer first. In answer to Mr. To's question, if the Commissioner specified in a certain manner the retention of certain products, say for example over the period of time, the provision does not stop the Commissioner from doing so. In the past, you have cited certain provisions to say that the Commissioner had no power, so it stopped Mr. Wu from doing certain things. But what about in the future? The Commissioner is of the view that there is a risk that materials during a period of time may be destroyed. Can the Commissioner say, I want all the products over a period of time to be retained for 10 years? There may be contention. You may put forward arguments against it. So I want it to be clarified that whether the Commissioner has the power to specify particular products to be retained and for a specified period of time. Don't use implied power. Because you said that, well, departments will adjust their code of practice. But when you think the Commissioner is doing more than it's supposed to, then you will say, well, there is no clear provision saying that you have such power. I'm still here. I want to make it clear. Otherwise, next time you will say, well, it's not clear and the Commissioner doesn't have this power. Yes? It's actually stipulated in the provisions. Section 53 empowers the Commissioner to check relevant documents and products. Section 59 sets out the protection of protected products. The principle is to destroy the products as soon as possible. And that is very important. When it comes to actual operation, they stem from these two sections. So no matter what procedure the Commissioner sets down, and no matter what arrangements there is to retain the information, Section 55 sets out that the protected products are to be destroyed as soon as their retention is not necessary. So for sections 53 and 59, is there a time limit? Can the Commissioner say there is a need? I want it to be kept for 10 years. And of course, the onus is on the Commissioner to ensure Section 59 is complied with. Now just give me a clear answer, yes or no. Yes, we'll give you a written reply. Mr. To, you're the only one left. I want to ask about paragraph 5. The 4 departments. Well, let me start with A, B, C. Is it the case that there are different codes for the 4 departments? That is in relation to period of retention. My understanding is that they have their own internal code of practice about interception arrangements. How come there are 4 different operations? If it's about destruction or period of retention, the principle should apply to all situations and all departments. It makes me worry that one may say 1 year, the other say 1 month. It's mentioned that in general it's to be destroyed within 1 month. No, but they said that there are 4 different codes. There are 4 different codes, but it doesn't mean that it will be for a year. It says that it's in general within 1 month. If all codes says the same thing, that is normally within 1 month, there is no need to have 4 different codes. By that, it means that there is a different length of period. If all 4 says within 1 month, then the administration would not say that there are 4 different codes. If they are the same, then there won't be 4 codes. Yes. There is no need to have this argument in the first place, because whether there are 4 different codes, it doesn't mean that there is a big difference among the 4 codes. When it comes to operation as set out in the paper, well, when it comes to original of interception products, in general, it will be destroyed within 1 month. And in general terms, the 4 departments differ very little. And under the legal framework, all departments will have to comply with sections 59 and 60. 59 stipulates that interception products have to be destroyed as soon as possible and practicable. 60 refers to 1 year after legal proceedings come to an end. And in relation to other documents, under Section 60, it stipulates that it will have to be kept for a minimum period of 2 years or 1 year after legal proceedings. And all departments abide by that. And in relation to the general retention principle, when a commissioner makes a request, then the product will have to be retained regardless of the period. If the commissioner requests retention, yes, there will be exception. If there is no exception, then how come one will say 2 weeks, the other one says 1 month? How come there is a difference in the level of protection or privacy?
It is as simple as that. Unless you can answer me as to why the 4 departments need to be different. Well, Ms. Lee, can you answer that question which is being repeated and repeated? Mr. Chair, I really do not see why we have to continue discussion on this question. Mr. Chair, it is because one department may afford 3 weeks and another 3 months. Why the customs is 3 months? Now, I'm taking that as a random example. And another department 2 months. That's impossible unless you can explain why. Otherwise, the people will ask you exactly why on the basis of this legislation. Mr. Chair, any supplement? Mr. Chair, the fact that she has no supplement doesn't mean that she has answered the question. Well, she cannot very well give you the answer as to which department will keep it for how many months. Mr. Chair, it is a matter of general interest. If there is a principle, that is, shouldn't she answer that question if there is a principle? Otherwise, she can choose not to answer any questions, Mr. Chair. Well, Mr. To, the question you asked is hypothetical. You're saying why 1 month, why 1 year, and Ms. Lee feels that it is something that she cannot disclose. Of course, if you want to query that, you can query it. Mr. Chair, I'm asking why the 4 departments will have different time frames. And you have been answering the reason why. My question is, why is that a secret? I'm not asking whether it is 2 weeks or 3 months or whatever, but why is it confidential? Mr. Chair, it is because we cannot make it public. It is confidential because it will affect the covert actions that the departments may undertake. Now, as for the originals of the protected products, the main point is that generally, after 1 month, they will be destroyed. So you can see that the 4 departments concerned will have the same kind of practice. You can construe it that way. Mr. Chair, actually, Mr. To doesn't have to be so worked up. In fact, the different departments will have the different ways of handling it, and one can understand it is a customs, ICAC, police, and immigration department. Of course, they will be different in their methodology and also of implementation and their guidelines, internal guidelines. If you say it has to be a cookie cutter for all, then I think I should be worried. We should be worried, because if the criminal elements know that it is a particular time frame or whatever time frame, they will tailor their actions accordingly. Now, these 4 departments are different in their time frames is acceptable. And what is important is that we look at whether there are loopholes in the legislation and whether the commissioner will have sufficient powers to implement the policy. If we go into overly detailed specifications, it is a risk for us. As legislators, if we think that this is in principle correct, then that is fine. And let us not be overly fine in our looking into the specifics or details. I think it is at present unnecessary. I don't think you can address Mr. To's query, but in any case, Mr. To, I think we have covered your question. Now, how many more questions do you have? Mr. Chair, I am facilitating the Secretariat or the Secretary in answering the questions in one go, because the areas where I am concerned about, I would want to ask them clearly on all in one go, so that we will not have controversies in the future. Now, I urge the administration going back and considering whether they will answer me the question. And tell me if you do not want to answer the question, why? You say confidential. Well, it doesn't mean that Mr. Yu represents everybody. And if it is confidential, tell us why. There are 2 points here. One, I'm not saying that it has to be a cookie cutter for all the 4 departments, but tell us, is it because of historic reasons or because in the future they will still be different? Tell us a reason. Oh, let's say the immigration or the customs or ICAC will have different ways of conducting their actions. But we're not talking about how they look into the cases, but rather the time frame. I mean, this is after their actions. This is after their procedures. So the duration after of keeping the materials after the procedures have concluded. Why cannot they be the same? Answer that question, that for one. And secondly, where the different departments may have different durations, 3 weeks or 4 months or what have you, I don't think that point is confidential, and I don't think it will adversely affect their actions or procedures. How come you think that even mentioning those time frames is itself a confidential matter? And thirdly, in the former Commissioner Mr. Wu's report, he was really angry and upset that certain recordings for certain cases were destroyed. And you say that according to his request, you have already preserved the protected products for his inspection. But that is a trick in wording only. You have followed basically your internal procedures. As for the commissioner, if his request for inspection comes after the time frame, then you would say, "Oh, sorry, destroyed already." So that by saying so, you are being misleading in paragraph 5 there. Now, also, another question: why is it not to destroy as soon as possible, quote unquote? What is as soon as possible? Each department will have different understanding of, quote unquote, as soon as possible. Are you saying that there is a different directive, and that is the head of the department can direct that the product is to be destroyed, or it can be deferred? That is, the excerpt or summary can be delayed in their destruction. Is that possible? Why is that possible? Why are not these materials to be destroyed at the same time? No, my assistant is beeping me, texting me. I do not know before I came into the room whether this question had been asked. I believe not. And that is, we want to ask the court. No, that is a question issued by the Secretariat, Electoral Secretariat. All right, Mr. Chair, let's say 3 months or 6 months. Can we have that time frame to digest this legislation so that we do not have overly burdensome resources layout, but so that we will know the full impact of the legislation? Have we asked that question in this meeting earlier, before I came into the meeting? No, the question had not been answered yet. Ms. Claudia Mo, you have raised your hand. Mr. Chair, for the record. Mr. Chair, you mentioned just now, for the question of Mr. James To, they are hypothetical questions. I think that is rather unfair comment. They are not hypothetical. It's just that his Chinese was not very good. He talked about consensus, etc. No, Ms. Mo, what I meant was clear. Well, Mr. Chair, I'm not trying to debate with you. I'm just telling you what I think. I'm very clear. that Mr. To is most concerned about. Why am I sitting at an angle? Distraction. Now, Mr. To is basically most concerned about just one thing, one thing only, and that is public's interest, and that is the right to knowledge or right to information of the public is to be preserved and upheld. And it cannot be that with just a response that this is confidential between the LEA and the commissioner would suffice. That's my understanding of his questions. Because of time, you are given 1 minute, Mr. To. Paragraph 12 there. It says that the information will be accumulated, and can you please accumulate that those cases, the number of those cases now? And also, I asked about the I have a question last time as to whether for outsourced companies, whether such personnel can also listen in to the materials. Well, if your answer is, well, if there is an outsourced company, then we will leave it open to them, then this is very worrying. My question is, what about non-government officers? What about non-disciplinary forces? What about those without affidavits? What about those outsourced companies? Because you say other personnel, they are also admissible. But this is exactly where it is fearsome for us. For those dangerous authorizations or outsourced entities, will they also have access? She's not answered me the question. Okay, so there are 6 questions from Mr. To. Well, Ms. Lee, Mr. Chair will answer the questions in a written form, but we will not admit or allow the conjecture that the LEAs are referring to this to avoid complying with the destruction period. AOBs, members, none. 14th of July, 2:30 p.m. Tuesday is the time of the next meeting. Thank you very much for coming.